Mr. Chairman and members of the Commission, I appreciate the opportunity to speak tonight. I echo President Infante Newsom's comments from the State Bar, and the work this Commission does is commendable and appreciated. I also want to note Governor Corzine's recent remarks, which have been widely reported declaring his support for full marriage equality in New Jersey. Governor Corzine's leadership has helped propel the state's transition to marriage equality from a discussion of if we should do it to when we will do it. Thank you, Governor Corzine, for your leadership on this issue. This support acknowledges the reality that this law is just not working in the real world. While the government feels that the change may come in 2009, it begs the question, if this law is a failure and people's civil rights are at stake, then why must we wait to fix the problem? Is it right for any community to be asked to hold off on getting their place at the table of equality for the sake of political expediency? When the Supreme Court handed down its landmark 7-0 Lewis v. Harris decision in favor of equal rights for same-sex couples, a slim majority of the justices authorized the legislature to choose between including committed same-sex couples in the marriage laws or trying to experiment on new statutory scheme called civil unions. As we know, the legislature chose to experiment and create a separate but equal category for gay and lesbian relationships that in fact is unequal. The New Jersey Bar Association issued its strongest dissent at the outset. While the law was being deliberated, stating that civil unions are, quote, unequal and unnecessary. We felt that they would cause problems for thousands of attorneys who counsel same-sex clients across the state. These were just words, not just words of prophecy, they were words of experience and wisdom, the product of great deliberation across our Bar Association and the wide ranks of knowledgeable legal scholars, leaders, and practitioners within the state bar. The civil unions law is a real application of Occam's razor, the principle attributed to the English logician Occam that says, all things being equal, the simplest solution tends to be the right one. The simplest solution here would be and remains marriage equality. The public policy pronouncements at the front of the civil unions law state, quote, eliminating obstacles and hardships same-sex couples face is a necessary and proper function of our government and a purpose of the law. But the reality, unfortunately, is that the law has not done that. The policy statements are important because the Lewis v. Harris court majority called out for them, saying, quote, if the legislature creates a separate statutory structure for same-sex couples by name other than marriage, it probably will state its purpose and reasons for enacting such legislation. Continuing on, the court said, although we do not know whether the legislature will choose the option of a civil union statute, the dissenters presume in advance that our legislators cannot give any reason to justify retaining the definition of marriage solely for opposite-sex couples. Members of the Commission, I report to you tonight that the civil unions law does not assert any basis, let alone a rational basis, for continuing to exclude gay men and lesbians from the definition of marriage. This is significant, not just because the Supreme Court specifically called out for this, or because it leaves the law with a fundamental legal fatal flaw, but because it appears to represent a rush to get something done without engaging in the thorough and deliberative process applied to most legislation in the State House. This is surprising on a piece of legislation that affects so many people in the most fundamental way. The lack of any legal or policy basis for maintaining exclusionary marriage laws in New Jersey is probably an oversight, but is symptomatic of a great number of problems that the law creates. Let me highlight just a few of those for the Commission. Mr. Chairman, I respectfully submit my first example of the failure of the New Jersey civil unions law. The state legislature, approximately 3 weeks after enactment of the civil unions law, amended the divorce termination statute, providing for irreconcilable differences as a basis for termination of marriages. However, unfortunately, the civil unions law was not similarly amended, and therefore, attorneys who practice in the area of family law are left to develop constructive arguments on a very expensive motion practice for their clients in order to allege this basis as a basis for termination of the civil union. I say this as one example, but it seems that we're going to have to follow, every time the marriage law is amended, we're going to have to amend the civil unions law. This, I respectfully submit to the Commission, is the essence of why separate is inherently unequal. Mr. Chairman, I respectfully submit my second example of failure of the New Jersey Civil Unions Law. The New Jersey Business and Industry Association reports that 66% of New Jersey's insured are in federally regulated ERISA health plans. As many of you know, the ERISA health plan is preempted under federal law, and therefore it's opened up a Trojan horse in the law against discrimination that would permit employers to discriminate. However, let me be clear, the vast majority of employers and businesses in the state do not wish to discriminate. What we find, and you'll hear later tonight, testimony from representatives from Massachusetts who come forward to tell you that ERISA issues are not a problem in their state. We only need to look to the UPS example, and again, we thank the governor for his involvement in that. But there's a number of other examples which are here as well as tonight, where ERISA is a problem in the state, where employers are looking at the civil unions law and understanding that they cannot provide benefits. Again, in Massachusetts, you will hear this is not a problem because Massachusetts has marriage. Mr. Chairman, I respectfully submit my next example of failure of the New Jersey Civil Unions Law. And I previously submitted to the Commission an example of a form of state employees. And as a practicing environmental lawyer, I'm quite familiar with this. It's the A901 solid waste licensing application, which is submitted under penalty of perjury. And it requires that individuals applying for a solid waste license in the state submit their marital status as well as the name, because the state Attorney General's office and state police do an extensive and thorough background check on anyone applying for a solid waste license. The bigger issue here is that there's countless numbers of forms out. The state has not made any effort to amend the forms or change the designation on there, which leaves a number of clients in the state of legal question of whether they fill out a form that says they're married or not. It's not clear under the law whether, in fact, a party to a civil union, as they're called, is legally married. Mr. Chairman, I submit my next example of the failure of the civil unions law. The state has undertaken considerable amount of work to try to bring its departments into compliance, yet this has not been successful. And I know that as a lecturer for the New Jersey Institute for Continuing Legal Education, I've had hundreds of attorneys and business representatives come to my lecture to spend 4 hours in a course in which they have to learn about completely new and separate law. And in fact, again, the simplest answer would be to have marriage equality be a lawful name. Mr. Chairman, I'm going to turn over the microphone back to you, but at this point I would like to introduce Leslie Farber, who is the chair of the GLBT rights section of the New Jersey State Bar Association. Thank you.